Hi all, welcome to this webinar. My name is Thomas and I'm joined by Yunze. Today we're very happy to have with us Mr. Bryan Tan. He's the director at PK Wong Nair. Bryan specializes in insolvency and commercial disputes. He is no stranger to contentious areas of law. Notably in 2015, he assisted in what was Singapore's first case deciding on the elements of thought of malicious prosecution of civil proceedings. More recently, he was involved in a case in which the court had an opportunity to examine the law regarding unfair practices granted to creditors of an insolvent company. Bryan is here today to give us insight into the issues facing small and medium enterprises during this COVID-19 situation. So Bryan, I'm very glad we could have you on board today.
Thanks, Guy.
And so for our listeners, by way of introduction, we'll be referring to the recently passed COVID-19 Temporary Measures Act, which is the overarching act which governs any laws which will assist SMEs during this period. We'll be referring to it as the COVID-19 Act. So maybe first we would ask, we would just want to state that this COVID-19 Act is a new piece of law which came into force on 20th April. It aims to provide temporary relief to individuals and companies facing financial problems due to the COVID-19 situation. And the pressure is placed on businesses. So Bryan, maybe given what you have experienced working in commercial disputes, what do you think are some of the limitations of this new act?
First of all, I think that given how quite quickly COVID-19 came about on our shores, I think the government reacted pretty quickly. Kudos to that. But I also think that because we tried to put in a temporary measure fairly quickly, there will always be some gaps that need to be filled. Obviously, one of the first limitations of the Act is the fact that the scheduled contracts only cover certain contracts. They don't cover every contract under the sun. So, for example, you may have unsecured loans that are not covered under the scheduled contracts, but they are covered in some other way. For example, they have kind of lengthened the period for complying with statutory demands or for a party to commence bankruptcy or winding up applications. Yeah, so, and I think overall also, everyone has to keep in mind that the Act is temporary. So we are looking at, the Act itself indicates, the title of the Act itself has the word temporary. And I think that's what parties need to think about, or everyone needs to think about, which is it's temporary. It doesn't solve a lot of long-term issues which COVID-19 brings. For example, these debts that are put on hold at the end of the prescribed period, which is coming up soon. These debts will have to be paid somehow. What the Act does allow is for parties to kind of negotiate with each other and try to come to some kind of agreement on how each party's cash flows can be managed. And then you're looking also at maybe potentially consumer behavior, a change in consumer behavior. I'm not sure about both of you, but I previously had never done any online shopping prior to this COVID-19. And I'm sure that online marketplaces have seen, an increase in their share of the market, and physical retailers are suffering. So maybe it also gives parties to put their debts on hold while they explore how to restructure their business models or their businesses.
Okay, Bryan, just to touch on a point that you mentioned earlier, you mentioned statutory demand. I mean, what could you explain what that is? Is it the same as like a letter of demand, or what context is it used for, and how has that changed in the COVID?
Yeah, that's a good question. So a letter of demand is simply a letter that's written with a demand for payment or to perform an obligation or to do something. A statutory demand, however, can be the same thing, but it is actually mainly for payment of debt. And it has consequences that a letter of demand may not necessarily have. For example, it used to be prior to the Temporary Measures Act coming in, the COVID-19 Act coming in, if you couldn't fulfill a statutory demand within 21 days, the person who issued the statutory demand is entitled to commence bankruptcy or winding up proceedings against an individual or a company. A letter of demand doesn't have the same statutory effect under the relevant statutes, but you are right. There is a difference, and the biggest difference is that statutory demand is really a precursor to some kind of bankruptcy or winding up application.
Okay. Sorry, you go for it first.
So, Bryan, what I heard was that maybe you were talking about how laws apply differently in some contexts. Do you think that there is a possible problem with information flow? I'm not saying that information is not getting out, but given that laws are confusing, do you think that there's some issues with interpreting how the various rules would apply to different parties?
Yes, I mean, that is principally why people need lawyers, thankfully. The laws are inherently, any form of text is inherently open to interpretation. You know, it's difficult to it's very difficult to say that a certain piece of legislation is very, very, very 100% clear and covers for every single situation. You know, the statutes are meant to be provide some general rules and indication for the courts as to how they need to decide the cases before them. But I think that, yes, there is always room to improve the wording of statutes to make it more accessible, more readable for individuals and the men on the street. But the problem with that is that when you do that, you lose possibly the ability to be precise about what you really want out of that legislation. And I think that the government has done a pretty good job of trying to balance that tension between trying to make the legislation understandable, but also not losing its legal position.
Okay. Bryan, there's something else that I've personally been very curious about, and something that I've heard from people. So assuming if I owe money to somebody, I'll say I owe money to Thomas, does that mean and I owe money before COVID?
In fact, you owe me some money, right?
You don't bring it up here.
that sounds like a lawyer already. But I'm just wondering, so does that mean the debt gets erased under this Temporary Measures Act? So what happens to it? Do I just not owe people money anymore?
Yeah, no, that's certainly not the case. And as I mentioned earlier, it doesn't wipe out your debt. It doesn't give parties a clean slate, or at least it doesn't give debtors a clean slate to kind of, you know, start over again. And unfortunately, while that's probably what a lot of debtors would want, I'm sure creditors would be very, very upset about that. And I think that really what the government has done here is, well, I'm not going to allow creditors to enforce or take action for certain contracts. But what you guys should do is try and discuss, you know, Thomas, you need to discuss with him, you know, what kind of payment schedule you need. I mean, I'm sure with all this happening, you know, cash flow is important, right? You want to see your cash in hand. You don't know what's going to happen after COVID-19. You know, if it does go away, you want to see your cash in hand today. You don't want to see it, you know, 6 months or 9 months down the road. And that's what the government really is trying to encourage, I think anyway, with these measures. Yeah, so to answer your question, it doesn't wipe out the debt. What it does is there's a big pause button and everyone has to kind of come together and decide what they want to do their respective obligations under any contract.
So actually, Bryan, you brought up a point about Yunze and I having to talk about my debt obligation. So maybe it's a good segue into negotiation. So given that the new act that's in place, it doesn't wipe out debt. It just, maybe if you want, it puts a big pause button on it. Then do you think there is any avenue for parties to act differently? Because I don't think people are going to want to sink money pursuing, they don't want to throw good money after bad to pursue debts at least at this time.
Yeah, I mean, there are two issues with that. The first issue is you may not even be allowed to commence any action under the temporary measures, under the COVID-19 Act. Second, even if you are allowed to commence action, it may take some time before you see, any money from the debtor, and that's going to take some time. That's going to incur legal fees, costs. So, one avenue that parties can explore is mediation. Some people think that you need to be in court and then you can go and mediate. That's certainly not the case. If you have a dispute or some kind of, disagreement, parties can always write to SMC or SIMC, and both parties need to agree that they want their dispute to be heard in the Singapore Mediation Center and try and work out their differences before an impartial mediator, independent mediator, and hopefully reach some kind of settlement agreement or agreement that everyone's happy with. So that's certainly one of the main avenues. I mean, the other thing is, if two parties are long-time commercial partners and they enjoy working with each other and they want to continue working with each other, then you may not even need a mediator. All you may need to do is just pick up the phone and, tell someone, can we discuss, can we negotiate, something like that.
All right, that's an interesting perspective that I don't think I thought about earlier, because you would think that, in a time of crisis, people would just be, commencing suits with
raising
each other,
the defenses, right?
Yeah. Yeah, exactly. So, I mean, does that mean that, Bryan, in your experience, you've seen that in the last few months, people have been a bit more hesitant to, go to court, to sue other people?
I think one of the factors that certainly someone thinks about before they commence a lawsuit is, how much money do I need to set aside if I want to really pursue this? And that can be a fairly big amount. And if it's something that goes to trial, you're looking at hundreds of thousands of dollars for a multi-million-dollar suit. And is that something that someone really needs to pursue now at this stage? May not necessarily be the case. I mean, normally there's a 6-year time limit to claims, and parties may, if I have 6 years, maybe I'll wait until everything tides over, and then when my cash reserves are better, then I will commence proceedings then. So it is certainly a huge factor, cash flow, in deciding whether or not to commence proceedings. So that's certainly one of the huge factors. Also, travel is a problem. If you have overseas witnesses, how's that going to work? I mean, the court allows for Zoom hearings now, but you do need to meet someone in order to really get a feel for how they are going to be as a witness. So that's a huge difficulty, I think.
So Bryan, maybe because your general work is commercial disputes, but I think the word disputes gives this sense that it's going to be a fist fight. It's going to be a legal fist fight in the court. So maybe for those who are tuning in, if they do want to seek, for example, mediation or negotiation, from your perspective, what are the differences? Is is mediation litigation light? Is it something that's not as effective, or is it something that should be considered at this time? Increasingly pertinent, especially in this COVID situation.
Yeah, so I think that mediation is always an option, and I think that now more than ever, parties should think about mediation. It's cost effective if you reach an agreement, and even if it's not cost effective, at least parties feel as if they've gotten enough to kind of they vented their emotions, their feelings. They've had their say, and sometimes that's what anyone wants, really. Yeah, so I think mediation is always an option, and you're right. You don't need a dispute in court before a party considers mediation. It can happen at any time, provided that both parties want to mediate.
So, Bryan, just now you're speaking on firms, cash flow problems, because we were talking in the context of, say, one contract is covered by the COVID-19 Act and another contract is not. So maybe you could give us your thoughts. Do you think this kind of problem is something that arises solely due to COVID? Or do you think that there is something that can be done or should have been done, or once COVID is over, it can be remedied in terms of the structural way that some companies are set up?
Yeah, so it's quite a lot of things to unpack there in your question. I think the first thing to understand is that I think COVID-19 is like in chemistry, it's like an accelerant. It's an accelerant of things for working from home. It's an accelerant for the way that our much more senior people of society have now to learn to use technology. So I think COVID-19 is also an accelerant in the sense that a lot of companies which were previously, living on a month-to-month basis, hoping to make ends meet on a monthly basis, just for, say, one period of the year where they could, make a huge cash flow because of one event or one festive period. I think COVID-19 has served to be an accelerant for their demise, quite unfortunately. And so, that brings us to the next question, right? Like you were asking about what can be done for these companies that are still surviving. Well, they need to think about changing their business models to something that's more sustainable, something less risky. So I think what you'll see maybe over the next few months or even after COVID-19 is you're going to see people trying to scale down their operations, scaling down their businesses. But I think that's a very temporary antidote. It's like a painkiller. It doesn't really solve much. The pain is still there. I think the only way to do it is to diversify businesses or to try and look at some other areas of growth. Yeah.
So in that regard, then, I mean, based on just what you've seen or what you can expect to see, are big firms, are big businesses and corporations getting hit harder by COVID, or are smaller and medium enterprises doing worse off? I mean, just what's your take on this?
That's a good one. I think a lot of it depends, on how these companies were prior to COVID-19 and whether they were smart enough to build up a huge cash reserve, to see themselves through this period. I mean, there's a rule of thumb in corporate, right? You try and keep maybe 2 to 3 months of finances, and I think that's the kind of reserve that you're looking at. But then you need to think about how you're going to keep doing it after that in the presence of COVID-19. I would say that larger companies are probably more affected because I think their overheads would be higher. There's no scale now that they can run off. There's no economies of scale now that they can run off because everything is in complete shutdown. So I think you will see the smaller firms being able to be a bit more flexible, but they have to be flexible and change. I think bigger firms, it would be harder for bigger companies to change, but I think because of the resources that they have, they'll probably be able to ride it out.
Bryan, we were talking about firms and we're talking about structure. So maybe if I could ask you, in your view, given that there are a lot of firms, I mean, there are a lot of firms which they just run the show however they want to run the show. Given that you said that COVID is a bit of a catalyst, a bit of an accelerant, do you think from a legal regulatory standpoint, this is going to have an impact? Because I'm going to be guessing that when the money stops flowing, creditors are going to start asking questions, and where regulatory issues pop up, the things that have been buried start to come to the surface. In your opinion, do you think this is something that may be relevant?
Sorry, I think you dropped off a little bit there.
Oh, so I was talking about from a legal regulatory standpoint, given if the money stops flowing and creditors start asking questions, and do you think that COVID is going to have an impact on that front? And is there something that firms should look at from a legal regulatory standpoint?
When money stops flowing?
Yes, yeah.
I mean, it's tough to say. I mean, what kind of regulatory concerns would arise as a result of this? I'm just trying to think in my mind. Nothing comes to mind at the moment as to what kind of regulatory concerns might come up. It's hard to tell. I mean, it's really hard to tell what kind of regulatory concerns might come up as a result of COVID-19. But the immediate ones, I suppose, would be working arrangements in the office. Working arrangements in workplaces. How a company is going to cope with social distancing. I mean, there's a lot of talk right now about the construction industry and how costs are going to be increased in the event of we don't have a vaccine, because there are all these regulatory concerns that have been imposed, and they cost money. I'm sure all of you know that already the cost of shopping malls have increased by the sheer fact that they need to put someone in the front door to make sure that you check in and scan. I mean, that's a very small example, but on a larger scale, you can only imagine how much cost that's going to add for everyone. Just, from the person who needs to hire them to who the cost goes down to, eventually the consumer pays.
That's actually pretty interesting. I mean, our whole conversation so far has revolved around not just the law, but also about, the way that companies are run, smart business practices. And, us being law students and you being a lawyer, people come to us and then they say, oh, okay, but I want you to solve our company's problems, right? How do we fix these problems? And so just based on your experience as a lawyer, what are the sort of legal mechanisms, or what are how can a lawyer help a business to protect themselves better in times of a crisis?
Well, it's always this is a problem, the divide between the client and the lawyer. Clients always think, don't tell me what I can't do, just tell me how I can do it legally, or how I can go about doing it without running foul of the law. But there are some things in law that are very clear-cut and you have to abide by. So I think as law students, as lawyers, our key responsibility is really to know the law and to advise our clients on the law. And, in some instances, if they don't like what they hear, then there's really nothing we can do. Your duty is discharged when you've told them what the law is. There are, of course, I think the value of a lawyer comes in trying to understand. We started this conversation, Thomas, with you asking me about interpretation of legislation, of the law and text. And I think that the value that a lawyer brings is helping the client navigate their way through all these texts and interpretations, and perhaps providing them with an answer that may not necessarily be so crystal clear at first glance. But yeah, I think as lawyers, our duty first and foremost is to advise them on what the state of the law is, and see if they've fallen foul of it, and if there are any exceptions to the rule. That's pretty much it.
Okay, I mean, sometimes businesses don't like to think about lawyers, and they don't like to think about, engaging a lawyer to help them out with, the drafting of their contracts or with any of their agreements. And have you, I mean, how as a lawyer yourself, I mean, what would you do? How do you encourage, these firms to, how would you encourage them to see the value in legal services?
Oh man, the age-old question. Well, it's not easy to bridge that gap. A lot of clients you see will ask, why do you need so much to do a simple loan agreement? And the problem is not all loan agreements are simple. And you're trying to protect the lender. You're trying to protect the lender or the borrower, whoever you act for, as best possible. And there nowadays there's this huge thing about you can go online and you get a standard form contract. But I had a matter that came a couple of years ago, and the guy was, we have an ironclad contract. There's a default clause that once they default, we're entitled to do anything we want. We can claim back the shares. We get our loan back, picked back immediately with interest. And I said, okay, yeah, let's have a look. And the contract came and yeah, it's got all these things. But then, the word default is capitalized, but it's not defined. And so there's no case. There's no case for enforcing a default clause that's not really defined. And I think that's why you kind of do need a lawyer. You need a lawyer to kind of make sure that these things don't happen, and that you have kind of what you're getting yourself into, so to speak.
Okay. Oh, okay. That yeah, and sometimes you need to hear from the lawyer yourself to understand what the benefits are, because the sad truth that I've seen is that people don't think about the law, they don't think about legal remedies until there's a problem or until there's a crisis, and by then it's a bit too late.
And that's where the litigators come in, right?
Yes, that's where you come in, Bryan.
Yeah.
So, Bryan, unfortunately, we're running out of time, and we're going to have to wrap up our discussion. But maybe this is a good point to ask. How about you? I mean, do you have any words that you'd like to say to owners of small business enterprises, or just anyone who might be facing a sort of commercial problem in these trying times?
Yeah, I mean, hang in there. Try and see where you can negotiate for a more flexible arrangement with whoever it is you owe obligations or payment obligations to. That's pretty much what the Act allows you to do. Definitely don't sit on your laurels. You have to really go out there and try and work things out. I think it'll be a waste if you think, this Act is in. I guess I just don't have to do anything until after the Act is, the prescribed period is over. That's certainly not the kind of thinking that you want to have at this time. Yeah.
Okay. That's very good. Thank you, Bryan. We have now come to the end of the session. I think it has been very helpful for me, for Thomas as well, and hopefully it has been for you as well. Throughout this discussion, we've talked about, not just the law, but we've also talked about what it means to be an SME in a time of crisis, what are the structural problems that exist, and just the wide range of ways that the law ties in with everyday business running. So with that, we'd like to thank you for joining us for this session. We hope that it has been helpful for you and your company. And should you be facing some of these issues during these trying times, we have a link to the Ministry of Law's COVID-19 circular that will be shown on the screen. Alternatively, you can also head down to NUS-COVID, that's NUS-COVAID.com. And that's where a team of us students have put up more resources and more information about the impact of COVID and what it has done and how it has changed specific sectors. So with that, once again, thank you for joining us for this session. Thank you again, Bryan. I think this has been very helpful.
Thanks, guys. And Thomas, if you need that loan enforced against Inter, let me know.
I'll give you a call.
Okay.
Thank you so much.